All right, hello everyone. Happy Wednesday. My name's Jackie Longstaff. I'm the marketing director here at the Cromeens Law Firm, and we are excited to present this webinar on construction warranties. Today, Karalynn Cromeens, our owner and managing partner, is going to go over everything you need to know about warranties, whether they are included in your subcontract, they aren't included, what you can be held liable for, what type of limits you can put on there, and answer really important questions like, do you have to uphold a warranty if you haven't been paid? So important things like that she's going to go over. A little bit about the Cromeens Law Firm. We specialize in construction law, specifically for subcontractors and material suppliers. We are based in Houston, and we have 2 additional locations in San Antonio and Austin as well. And Karalynn has been doing construction law and specifically focusing in on subcontractors for almost over 15 years. So she knows everything you can know about a subcontract. And I think we're going to go ahead and get started. And just one last thing before we get started, if I can ask everyone to please mute yourself. And we are going to end the presentation with a Q&A. So at the end, you can either put your questions into the chat box and I'll read them aloud, or you can unmute yourself at the end to ask that question. Please keep yourself muted during the presentation.
Gotcha. Okay. So warranties is something we don't normally think about a lot until a warranty claim is made. And so we're going to dive right into how warranties affect you, whether you know it or not. There are 2 different types of warranties: express and implied. An express warranty is a written one that you normally find in a subcontract or any kind of documentation you give to your customers that explains your warranty. An implied warranty is the one that the law implies whether you give it in writing or not. And today we're going to go over those 2 different kinds of warranties and which ones are best and how to control your liability under a warranty. An express warranty is one that is written in your contract and basically describes the warranty period, what you're willing to cover for the warranty, what's covered, what's not covered. What I normally see with express warranties in subcontracts that subcontractors are not aware of or take into consideration when they're doing their bid or before they begin the project is first that normally the express warranty that's in a subcontract doesn't begin until the project's complete, which sometimes could be months, maybe years after that particular subcontractor has performed his work. So you need to make sure that you read the subcontract before you sign it to know exactly when your warranty period starts and how long it's for and what exactly does it cover. The other thing I want to point out with express warranties in subcontracts is that normally, in addition to the subcontract warranty, the prime contract has been incorporated into the subcontract and any warranty included therein. So, meaning before you can truly understand the warranty that you're agreeing to give in a subcontract, you need to request a copy of the prime contract and make sure that it's the same time frame, the same definitions, and make sure that it's the same. You're not agreeing to something unknowingly larger than what's in the subcontract. So you don't have to use any special words in express warranty for it to be considered to a warranty like a guarantee. Just you have to spell it out. And we'll get into some other things you can disclaim later on. An implied warranty is what Texas law provides just by the fact that you're working. There are 4 of them. The first 2 we're going to go over is merchantability and fit for a particular purpose. All right, the warranty of merchantability makes, in general, that what you're doing, either the material you're supplying or the labor that you're doing, will be good for an ordinary purpose and a fair quality. That's just generally. The one for fitness of a particular purpose is a higher level warranty and only applies if you, the seller or the subcontractor, are aware of what your client's going to be using it for, and you know that at the time of the sale or the time of the transaction. Then it puts you at a higher standard that the work that you're doing or the labor you're supplying is fit for exactly what your customer end user is going to use it for. There are 2 other implied warranties that Texas applies just by the fact that you're doing work and is not, if you don't have a written agreement, is the warranty of good workmanship and habitability. If you can go to the next slide, I think it's got there you go. Good workmanship basically says you're going to do your work in a good and workmanlike manner, and somebody can rely on that. Generally speaking, that the work that you should do and the time frame should be good for at least 6 months, if not longer. Having a customer rely on that work for at least 6 months, if not longer, is a reasonable expectation of good and workmanship-like work. The next one is for habitability, and this is basically for residential construction. If you're building a house, the law, and you don't have a warranty, the law automatically builds in a warranty that they should be able to, that your customer should be able to live in that house or live in that structure, or whatever you're doing for residents should be able to do what you said it should do. And this would also cover any latent defects, which are defects you can't see from the surface that wouldn't appear till years later. Like if there's a latent defect is found to be if there are leaks in the stucco that cause the beams in the building to go bad, that would be considered a latent defect. And although it may be years down the line before that's discovered, the original builder would still be responsible for fixing those latent defects, even though the house may be on its 3rd or 4th owner at that time. How does the warranty benefit the subcontractor? Having a written warranty, one of the ways that it will benefit you is you can limit your liability. You can limit, normally you can get consequential damages as part of a warranty, as part of an implied warranty. Meaning, for example, say, I think we have the pipe burst example. I had that happen to a client, is that a pipe he installed burst. He had a limited warranty that only made him responsible for replacing the pipe, not all the damage, the water damage caused by the pipe bursting. And generally speaking, even if you don't have that type of limiting language in an express contract, your insurance would cover, if you have insurance, which is always a good idea to have, any consequential damages that are caused by a defective product or something like that. So, but in order to have that, you need to have an express warranty, which, can you go to the next slide? Which we're going to go over the breach of express warranty, the breach of implied warranty, and DTPA, or deceptive trade practices. All right, a breach of an express warranty is when you have a written warranty and it's in writing, and your customer, whoever's suing on the warranty, relied on that promise that you did good work and was damaged when the products weren't what they were supposed to be. This is an express warranty claim. It generally happens when you don't honor a warranty claim, and you should. And you would be held to whatever standards are in that written warranty. So that's an express warranty. An implied warranty is a little less onerous. It's just that you sold it, they were unfit, and there was damages because of it. It's not as high a standard, so you can protect yourself, make it a harder case to be made against you if you have an express warranty, which is always a good idea. Especially since when we get into the DTPA. Okay, so if you're dealing with a consumer, which is anyone who's not a business and sometimes can even be a business, who's buying your services, and you have an express or even an implied warranty, and they sue you for breach of this warranty and they qualify as a consumer, the claimant will be able to, if they're successful, recover their attorney's fees, Normally, a breach of warranty claim by itself doesn't allow for the recovery of attorney's fees. But if they bring in the DTVA and say what you did was even more egregious than a breach of warranty, it'll include, they can recover their attorney's fees. They also, under certain circumstances, if the work or the damage is bad enough, would be entitled to triple damages. Meaning if your work caused them damages in the amount of $20,000 and they can prove you did it fraudulently, they could times that by 3. So, you know, $60,000 recovery instead of just a $20,000 recovery. Those are very high standards to work, but just the fact that you have to deal with it in litigation is something enough to be considered to have, you know, express warranties and really have it spelled out what you're going to cover. Which at this point, if you don't have a written warranty written by an attorney, which is also a very good idea. All right, the disclaimers, which is what you can put into an express warranty. You can limit your liability under the implied warranties, which are the warranties that are enforced against you if you do not have a written warranty. So in your written warranty, you can say expressly what you're agreeing to. You can also limit your liability for your warranty of merchantability and fit for a particular purpose. It has to be, if you're going to do this successfully, you have to have an express warranty, and within that express warranty, you have specific language that says you're not going to be responsible for these implied warranties, and it's got to stick out. It's got to be enough so a conspicuous person, if they read it, would realize that these implied warranties are being disclaimed. Sometimes you'll see it, I know a lot of times you'll see it on the back of receipts or on the back of purchase orders where these implied warranties are being disclaimed. It's not uncommon to have it done, especially at for materials, or like AC work that have you just a purchase order, and on the back it's got the terms and condition, which if done properly can truly limit the liability under an implied warranty. The same thing for a fit for a particular purpose. You need to put that language in there to show that you're not covering that type of warranty. You're only covering the express warranty that you include in your subcontract or in your purchase order or your agreement at all. The best practices is to have a written express warranty that disclaims these type of warranties. Next slide. You can also limit the warranty of habitability. If you have an express warranty in your subcontract, you can limit your liability as to latent defects as well. So not having a warranty in your subcontract, especially in a residential situation, doesn't mean you're not going to issue one. You're just going to issue one that you're not in control of. So having the correct written language included in your subcontract, or knowing what the express written language in a subcontract you sign means is extremely important. All right, positive and negatives of warranties. You can limit your liability under warranties by having an express warranty. You can also limit the consequential damages by having an express warranty, which is the damages that may result because of defective work. The negatives are, if you don't have one, the law automatically implies the implied warranties. So having a written warranty is essential. The other question I get a lot when it comes to warranties is, do I have to issue a warranty if I haven't been paid? And generally, most subcontracts call for you issuing the warranty with your final pay application. So at the very least, you're issuing your warranty before you've been paid retainage. And so what I say is best practices is that you issue the warranty with and I believe that the language to limit it is in the most recent blog article, with the restrictive language that this warranty is being issued, but no claims will be honored until you've been paid in full. and whether that is the remaining amount retainage or more if you're owed more money. Because technically, if your contract requires you to issue the warranty before you're paid, you need to do that. Otherwise, you'll be in breach of the contract. But you can limit when claims can be made, and that you won't honor any claims until you've been paid in full, because it's unreasonable for you to go out and fix things when you haven't been paid in the first place. And so having that type of language or adding that type of language into your subcontract is essential, so that you don't have to go fix work that you haven't been paid for yet, which is where I see the warranty issues pop up a lot. Like I said before, the other things that you need to consider when agreeing to a warranty in a subcontract is that the warranty period doesn't normally start till the project ends, which you don't know when that is. Could be months, if years after you complete your work. And just having a written warranty that you understand. Also, knowing what the warranty in the prime contract says, because you'll be agreeing, in most subcontracts, you'll be agreeing to the terms of the prime contract as well. I know warranties is not something you normally think of until you get into a warranty dispute, but knowing on the front end what your liability is and trying to limit that liability by having a written warranty is key. And so now I'm going to kind of open it up to any questions anybody might have about written warranties, implied warranties, just warranties in general.
Thank you so much, Karalynn. Yes, please, everyone, if you have any questions, you can either send them through the chat and I'll read them aloud, or you can unmute yourself and ask Karalynn directly. This is a great opportunity if you have any specific examples or situations that you may be currently dealing with or dealt with in the past, to get Karolynn's kind of advice and on them. So I'm going to open it up for questions.
I have a question.
Yes, sir.
As I'm in the fix and flip and I buy a house and I'm going to have a contractor repair it, how does this affect my relationship to him and the ultimate buyer?
So you bought a flooded house, you're hiring a contractor to repair it?
Right, and then I'm going to sell it to somebody else.
Okay,
So that's two different people.
I agree. And I think if the flood is, I think you have to disclose it to a seller if it's flooded in the last 6 years. But with that disclosure, you can also put in there the contract of what you hired him to fix. And then I would have him have a written warranty in his contract of what he's going to cover and what, so that a new buyer could see that.
So the warranty, the contractor's warranty passes on to the new buyer?
Correct. And I would put that specifically in his contract as well too. But yeah, it would. And they're going to want to see that. I'm sure they're going to want to see that once you disclose the house is flooded and exactly what you did to fix it and who did it.
Great question. Thank you. Do you have any other questions?
Another thing I forgot to mention is that if you're installing products, normally the manufacturer will have warranties that you can include with your warranty packet, so you can get a copy of those.
Another question.
Mm-hmm.
So does my warranty, anybody exceed what the manufacturer's warranty is on a particular product?
What was the question? I'm sorry, I missed it.
Well, the manufacturer of products that are used within the house,
Mm-hmm.
those manufactured products have warranties. Would my warranty exceed that warranty, be wider or greater than?
Yeah, you can make it bigger than that. You'll get as a base the material supplier's warranty, their general warranty, and then you can have the subcontractor can obviously warranty the labor or even warranty the materials for longer than that if you can get them to agree to it.
Thank you. Do you have any other questions?
I have another one.
All right.
What kind of an agreement is it that you would write up to protect me as the contractor that I hire? I'm not quite sure how you fit into what I do.
So you're hiring a contractor to fix a flooded house. So basically, you're
Well-
gonna need a general contract, a prime contract, or a subcontract that spells out all the terms of what he's hired to do. It spells out not only the warranty period, but all the other that he's going to have insurance and all the other things that you need a full contract if he's going to be doing the whole house and not just doing one section of it, which is something we can help with.
So really what we're talking about today has to do with if I am a contractor, not if I'm a person hiring a contractor.
Either way, it's better for you to have an express warranty in a written contract as well. And I would definitely have your agreement with your contractor they're hiring in writing and have all the terms spelled out.
Well,
One of which
usually-
is the warranty term.
Right. Usually when I would hire a contractor, they would want me to sign their agreement. But shouldn't I have an agreement that the contractor signs as me employing him?
What
That
I would
protects
do
me.
is I would look at his agreement and see what you want to add. There should only be one agreement, and you can add the stuff you need to his agreement to have one agreement that explains everything. So if you want better warranty terms than what his contract provides, you can add it to it. If you want a better description of the work, of the scope of work he's going to do, you can add it to it. If you want him to have better insurance, you could change his contract to require that.
Thank you.
Karalynn, I have a question, and it kind of ties off of his last question. So, if there's a warranty in the prime contract, in their subcontract, or are they automatically held to the other?
They would be held to whatever one's stronger.
Okay.
Whatever one gives more to the customer, to the client, which is why to know if those on the front end, to know if those things are in conflict.
Okay. So even if their express warranty stated that, it only covered work for 6 months after the job was completed, if it was prime contract,
Correct. If the prime contract says that the warranty doesn't kick in until the completion of the project, that's what they'd be held responsible for that, in addition to what's in the subcontract.
Okay. So that's why it's so important to make sure that they're reading all of that and negotiating what's in the prime contract.
Correct.
All right. I've got another question here from Eric. He says, we give a general NAHB express limited warranty. Is this sufficient to cover ourselves as a customer?
I would think so, but I would want to review to know for 100%. Especially, I would want to know a little bit more about what you do particularly and who your customers are. Because especially with the DTPA involved, you're dealing with consumers, you need a little bit stronger language. So generally, yes, but to be 100% sure, I'd have an attorney look at it.
Thank you. Any other questions? If there's anything in the presentation you felt like wasn't covered, this is the time to ask.
In general, if I were going to be the contractor and you were going to draw up an agreement for me, what range of expenses would I?
I think we have a flat fee for that. What is the flat fee for the subcontract, Jackie?
Yeah, they range from about, I think, $1,000 to $3,000, depending on how long the contract is, exactly what type of contract it is. But after this webinar, I'll send out the presentation, and I'll also include a link to the law firm. We do accommodate flat rate pricing, as well as general retainers.
So as much as possible, we could look at your situation and give you, you know, if you only need a 4 or 5 page contract, obviously it costs less than
Yes.
somebody who needs a 30-page one. So, but we could give you a flat fee up front depending on what you needed.
Yes. And it's also less expensive if it's just reviewing a contract you may already have. I think that's about $500 versus creating a contract from scratch.
Is your focus primarily with contractors, or would also do real estate in general?
We do real estate law as well. If we don't have any other questions, we'll go ahead and end the webinar. I know everyone's got a busy day to get back to. Like I said, I'm going to send out a link to this presentation, as well as Karolynn's contact information. If you have further questions or you have specific warranties you would like to look at, and all that information out there. Thank you, everyone, for joining in.
Thank you.
Have a good day.